Welcome to Solving Citizen Legal Encounters. All right, today we'll be in Judge Washington's court where we have a pro se defendant that I covered a few months ago that was due back in court for a landlord-tenant issue. So in today's video, you're going to have 3 hearings. So the only video that's pre-recorded that I posted previously is the second hearing. Before we get into the video, I want to welcome Neil, Wanda, and Brooke to the membership. Thank you for joining. And look in the community post. Is something there for you? Let's go.
The court will call the case of Portfolio Recovery Associates LLC versus Shatina Grady, also known as Shatina Grady L.
Good afternoon, Your Honor. Daniel Best, P58501 on behalf of plaintiff, Portfolio Recovery.
Good afternoon. I should have also said case number 24C2622GC. Ma'am, could you state your name?
Shatina Grady L.
Thank you. All right, we're here today on these motions for summary disposition, cross motions again, as well as now Ms. Grady L has filed a motion for arbitration. I think we should start with the threshold matter of the motion for arbitration. Her claim is obviously that it is something that she's entitled to and that the court doesn't have any discretion in allowing her to have that. The response file, which I have reviewed, argues essentially that she waived that particular right when she chose to go down the route of filing for a jury demand and having multiple hearings regarding this matter prior to filing for the motion for arbitration. So Ms. Grady L, it's your motion. I'll let you make any additional arguments that you want to make regarding that.
Okay, I never received the answer to this motion to compel arbitration either. I just would like to let the court be aware of that. I don't understand what is the reason that Portfolio Recovery and their associates tend not to send me information according to this case when they're supposed to send it. And to me, that is very deceitful. They are hiding something, and I am compelling the court to send this to arbitration because they also have, for the public record, defamed my character, Shatina Grady L, by making false statements. They have said just recently in their response that I have not seen that you said that I shouldn't be allowed to go forward with this because I have asked for a jury. That is incorrect. I have not filed to have a jury. I asked about that before I. So like this Portfolio Recovery is a very deceitful, and their associates is being very deceitful in this case.
So my notes in the file from the magistrate when you met with the magistrate was the defendant requested a jury trial. So that is.
So I did speak with her about that. I asked if I could, and she said she did not know. She had to check. And if you needed to run back the tapes, that's exactly what happened, because I did not file any paperwork for that. But I asked when I spoke with her, and she said, I don't know.
Now, we all know from experience watching Sovereign Citizens or Moorish that when they go from one court to the next, they always say that something happened differently in the court, even though it's on record.
Okay. Well, the bigger piece is that there have been multiple hearings on this matter and that you have not filed any. Well, I'll let him make his argument. Mr. Best?
Thank you, Your Honor. As detailed in our reply, we believe the defendant has waived the right to arbitration in this matter. I mean, this is the third hearing we've had on our motion for summary disposition and the related motions. This matter was filed in October of last year, November of last year. It's now May. We are in heavy litigation. Numerous pretrials have been held. Numerous hearings have been held. Quite simply, the ship has sailed on arbitration.
And I would like to dispute that because according to you, you are saying that numerous ships have sailed, but your firm in handling this case has not handled it correctly. So you yourself have filed as Exhibit A something that speaks of arbitration, correct? So you are in knowledge that there should have been arbitration before bringing it to court. You did not. You
We made no such acknowledgement, ma'am,
didn't make no
and
acknowledgement
we
for
have not been deceitful. I find that offensive.
in your exhibit A, it distinctly says that any one who comes and takes said debt that you said you were assigned, you are held to the agreements of Synchrony Bank that there is to be an arbitration first before seeking to court. Now,
That is,
in
that is
my
correct.
opinion, that is not
You
my fault.
need to read the statement. You need to read the agreement.
The law is the law. I did read it. I have it in Exhibit A. Look at Exhibit A. Because I don't have a contract, neither does the defendant with you.
Is she speaking in third person?
And so your company has repeatedly failed to answer these motions or anything with the information that I have requested. And that
May I
is
read the
that
provision?
certain
Would you
information.
like me to read the
All
provision?
right, everybody, please slow down and stop. She can't record all of that like the way you're talking right now. Mr. Best, please read what she's reading from as to whether arbitration is required.
Yes. If either you or we make a demand for arbitration, you or we must arbitrate any dispute or claim between you or any other user of your account and us, our affiliates, agents, and or dealers, merchants, retailers that accept the card or program sponsors it relates to your account, except as noted below. Basically, the noted below is the small claims provision, standard language, but the arbitration is elective. It's not required.
So I am requesting that the court compel this to arbitration because it says in 9 USC that the court, for staying the court proceedings when an issue is referable to arbitration. If a lawsuit is filed on an issue covered by an arbitration agreement, which there is one, okay, the court must stay, it says must, the proceedings and compel arbitration if the issue is properly referable to arbitration. So it does not say I have a time limit to, unless you can show me where it says that I have a time limit to request an arbitration.
Michigan case law is very clear about waiver.
So everybody stop. So Ms. Grady out, give him one moment since you didn't receive it. So we didn't address that issue. Her issue is that she never got the reply brief, but I want to handle this today. So I want to say that it was filed with the court on May 20th. Today is May 22nd. And I don't know whether, let me see, where's the proof of service on this? One moment.
And I am consistently, when I file paperwork, giving them notice of at least about 2 weeks or close to 2 weeks. And repeatedly, they are sending information to me at the last minute. And it is obstructing. It is obstructing proper defense on my side because they are repeatedly, every single time they are sending things to this address at a late notice where there's only a couple days for review. I am sending it in enough time for them to view it, process it, and respond. They are not. They're being deceitful. They're not being honest.
So it looks like, Mr. Best, your office didn't put this in the mail. So you brought it to the court, apparently. It was dropped off. You brought it to the court and dropped it off on the 20th, but you put it in the mail to her on the 19th. There's no way possible she's going to get that.
We mailed it to the court. We received hers. Bear with me.
It was mailed on the 12th. I mean, mailed on the 13th. Let me look at my receipt. I do have my receipt right in front of me.
His point, though, ma'am, is if you mail it to them on the 13th, by the time they get it and have time to respond.
We literally turned it around in one day, Your Honor.
Yeah, it's going to have a very short turnaround time, regardless. But this is not folded, so I think your office delivered it to us, Mr. Best. It could have been put in one of the.
I don't believe that is correct.
Well, I don't think it's possible.
We mailed
it. Well, then if that's the case, I would have an issue because you mail it. It's not going to get to us. If you put it in the mail on the 19th, it's not going to get to us on the 20th. That's not it.
Yeah, we sent it overnight FedEx.
Okay, did you send an overnight FedEx to her?
We sent defendant first class mail.
So she's not gonna get it, so she doesn't have it. So that means, Mr. Best, that you need to read the case law that you're citing to her so she can at least hear what you're saying is your argument, because she doesn't have the document.
Very good.
So again, I would have no time to respond. I am not an attorney.
She decided to represent herself.
I don't have this terminology in defense.
Grady-L, Miss Grady-L, Miss Grady-L, Ms. Grady-L, I'm very, very aware of that. So please understand that I'm taking that into consideration, okay?
Thank you.
Okay.
Mr.
And,
Best,
do you want me to read the germane paragraph, Your Honor?
correct.
Okay. The presence of a no waiver clause to arbitration does not alter the ordinary analysis undertaken to determine if a party has waived its rights to arbitration. Citing to S&R Company of Kingston versus Latana Trucking, Inc., 159 F. 3rd 86
reading
at
from?
page 86, Second Circuit, 1998, cert denied, 528 U.S.
Mr. Best,
1058.
Mr. Best,
Yes,
where are you reading from?
I'm reading from page 5 at the very top. I went to the actually I could go back a paragraph if the court.
Well, it's not numbered, first of all, but you're reading from page 3?
Yeah, I'm sorry, page 3. Yeah. Let me start at the bottom of page 2.
Okay.
Okay. Unless the court would like me to start somewhere else.
No, that's fine.
Okay. In presenting a motion to compel arbitration, the moving party must do so without 1, taking actions that are completely inconsistent with any reliance on an arbitration agreement, and 2, delaying its assertion to such an extent that the opposing party incurs actual prejudice. Citing to Hurley v. Deutsche Bank Trust Co. Americas, 610 F. 3rd 334 at page 338, year 2010. It does identify a quoting case, and then it also identifies to see General Star National Insurance Company versus Administratia Aseguilar Distrat at 289 F. 3rd 434 at page 438, 6th Circuit 2002. Goes on that the presence of a...
Mr. Best, let's stop there.
Okay.
What is the actual prejudice to you?
We have spent a considerable time and effort briefing, appearing at hearings. We've engaged in litigation. That's all held for naught if the court now refers this to arbitration. That's valuable time wasted, including the court's time. And I believe we are definitely severely prejudiced in the number of times we've appeared before this court.
I would have to respond that I am also incredibly prejudiced because information I have asked for and the plaintiff has supposed to sent to me in a timely manner has not gotten there. I've too had to appear at these appearances. I too had to take time to do research, probably more than the plaintiff, because I don't know all the terminology. They have an upper hand.
Question: how can you go pro se and then complain that you don't know the law or the rules because you decided to go that route? Let me know what you think about that in the comments.
So I too have been very prejudiced, and then I too am the plaintiff is trying to prejudice me even further by asking for finances that they have not yet or failed to prove that they actually deserve. The plaintiff has repeatedly, because the defendant,
Who was that?
I believe, in my opinion, does not have an attorney, has taken advantage of this situation or attempted to take advantage of this situation by not giving information late, and also filing, not responding how they should. I asked for specific information to even prove a contract between the two, not giving it. You were told by the court to send some unredacted documents that you put on public forum for people to see. It was placed on public forum, unredacted documents that should not have been. Those should have come to this address. So in your speaking of anybody being prejudiced, that would be the defendant. Is grossly. And I ask that the court compel this to arbitration, which is where it should have been in the first place.
Your Honor, I can only point out that the clause was attached to the complaint. The clause was, the arbitration agreement was attached to the complaint. So I have no idea what defendant is complaining about.
And I too said,
well, everybody please stop. What she's complaining about is the fact that when the request was made by her to get a copy of the documents that proved that this was a valid contract, her personal information was included mistakenly by your office with the documents that came to the court, as opposed to the documents that were supposed to go to her. They came to the court and were placed in the public file. So that's the prejudice that she's referring to.
Okay. And I would move to have that stricken.
Right, I understand that, and we will strike that. We've already instructed the staff to do so. But that's the argument she's making as far as that part is concerned, because she wasn't able to see the actual account to be able to know that it was her particular account. That has been something that she has stated from the very beginning. The second hearing that we had to have was because the documents were FedExed to her shortly before the hearing that we were supposed to have, and she had not had time to review them because she was out of town. The first hearing that we had was at the court's request for the matters to be briefed more thoroughly, because she had filed responsive pleadings and no one had briefed every single one of her responses so that we could have an actual hearing on each one of those. So there has been a lot of litigation. I understand that there has been a lot of litigation, and Miss Shatina Gradiel, Mr. Best is correct. The concept of an arbitration as it was indicated in this particular contract is one that is elective, meaning that a party has to elect to have it. They're not precluded from coming to court in this particular case, and they were not wrong for bringing this case to the court. However, you have now made a demand for arbitration in this case. And so as I see it, and Mr. Best can choose to appeal or do whatever, but as I see this, the issue before the court right now is whether or not there has been an extensive amount of litigation to the point that the plaintiff portfolio is actually prejudiced by that. They have expended a considerable amount of time coming back and forth to court here. But that does not, in my mind, equate to necessarily a prejudice. I am going to grant your request to compel this to go to arbitration. But what that means for you, ma'am, is you need to file the documentation to go to arbitration. I will stay it until you do that. I'm going to stay it for 30 days. If you do not file that in that 30-day time period, we will come back here and there will be no more requests. Okay?
Yeah.
So you need to file the monies and go to arbitration. The motion to compel arbitration is granted.
thank you.
Thank you, Your Honor.
You're welcome. Ms. Brady, are you going to prepare the order for that?
Yes.
Well, do you want her to prepare it? You guys don't even talk to each other.
Your
so-
Honor, I have a standard order I can have prepared and submitted.
As you heard, there was several hearings with this case. I was only able to grab the ones that you're seeing. but it's enough for you to see what's going on, and we're going to continue through. So the next hearing is one that I already covered, and it's already commentary with that one. Let's go. All right, today we're in Judge Washington's court where we have a pro se defendant who's in court for a debt collection case. There's some things that didn't go right on this case, and Judge Washington is going to address it between the pro se defendant and the creditor.
All right, the court will call the matter of Portfolio Recovery Associates LLC and Shatina Grady. 24C 2622.
Thank you. Good afternoon, Your Honor. Daniel Best, P58501 on behalf of Professional Recovery.
Thank you. Please state your name, ma'am.
Shatina Grady L.
Thank you. All right, the last time we were here on this particular matter was back on May 22nd, 2025, when I granted Ms. Grady L's request to stay this matter and compel arbitration in this case. And it was set for a review today to determine whether she had filed or we were moving forward on the MSD.
So I come today to have my motion for dismissal requested. And
Ma'am, what happened with the arbitration?
So there was no arbitration because that attorney that took the information mysteriously emailed it to the wrong email. I called them on May 23rd, on June 9th, because I had checked my email. If you will recall, at the end of that last court date on the 22nd, the attorney that spoke or sat was supposed to send me information regarding arbitration. I checked the email every single day. There was nothing. On June the 9th, I called to find out why I had not received anything, and I had to leave a voicemail. I did that. I called on July the 1st to find out why I had not received anything and what is going on, because I'm still checking the email. Nobody's called me back. Nobody has reached out to me by mail, nothing. On July 2nd at 8:37 in the morning, they had a representative call me. When I spoke with Kelly at 3:02, finally getting in touch with someone, she said, even though this attorney at the last meeting repeated the email back to us, managed to misspell the email when they sent out the arbitration stuff. So as of today, when I checked, I still have no arbitration stuff, because on the 2nd, when I spoke with Kelly, I gave her the corrected email. I don't understand why this firm is unable to get me the information that I need, either not at all or in a timely manner. I don't understand why, when they can repeat back to me what I have given them per the email, that mysteriously one letter gets changed. So arbitration has not gone through on the failure of their behalf.
Mr. Best, response?
Thank you, Your Honor. I was that attorney. I repeated back the email address that was provided by defendant. I reiterated the E because it was not her last name. I mean, not her first name. It was Shantine, not Shantina. And I got confirmation. I completed the order, and it was an order of stay. There was nothing in that order that would preclude defendant from seeking the arbitration as was ordered by the court. So the email that was sent was not returned undeliverable. We did not have any notice that there was an issue until yesterday when my staff returned the call. Admittedly, we did receive ISHO on June 10th, a call that was misrouted by my receptionist and was not returned. But the bottom line is, at that hearing, the court gave defendant until today to initiate the arbitration. Nothing in that order was needed by her to initiate the arbitration. and the arbitration was not initiated.
So in response to that, at the last court date, I spelled out SHATINA G 317, and I said G for Grady, right? And so you repeated that back to me. First, you asked if it was the E, because in the new name, it is SHATEINA. And I said, no, it's not. You asked me, was it going to be spelt that way? Because it's different from what, and I said to you, no, not to that name. We're not spelling it that way. We're not using the E. I specifically said we're not using the E in Shatina, SHATEINA. And then I also said G for Grady, 3. But the email that you sent it to, if I'm telling you there's no E from what you see on my sign-in, SHATEINA, because that's what's on my sign-in, I told you to omit that E. That doesn't go there. We're going to, it's spelled the way that it's in the court papers that you filed suit of, if it's in front of you, you filed suit for SHATINA, okay? And then Grady. And then as to what you sent me, and you saying that the court said that I had to do, if I want to seek arbitration, she asked me, did I know how to do that? I said, no, but I could figure it out. You said, well, I can send an email. Whatever your specific words, which is why I'm getting transcripts printed. I don't know what your specific words, but you cut in and said that you would send me the email. That's when we got to the email aspect of it. That's how we got to the email aspect of it, because I had said, she asked me, did I know how to do it? I said, well, no, but I can figure. And you said, well, I can send, you said, I'll send an email, or whatever your wording was. You didn't say anything about sending whatever you just said that you were going to send. So again, you're playing games, and you're being dishonorable, you're being deceitful. You have not
Miss Gradio,
yes.
please stop going down that line.
You know, she's painting that picture, hoping to get that dismissal granted that she was looking for.
I'm just telling
Miss Gradio, the
telling
reality is that you came in here and you asked for an arbitration.
yes.
And I stayed this matter and gave you an opportunity to file that. So,
But he also said, when you asked me, Judge, you asked me, and if you needed to run the transcripts back, we could do that. You said, do you know how to do that? I said, no, but I'm sure I could figure out. And he said, as a cut-in, that he has a packet that they normally send out. Nor not I have received that packet, but I didn't receive an email for it. I knew that I would probably not get any response until close to the court date. Like, I knew that. That's why I even called on June the 9th. That's why I even asked if there was a note I could send you at the court. And I was told no. I knew that they would try and do this.
And from June 9th into her hearing, which is in July, she didn't do anything.
That their people called me just now, yesterday. And if the court rules in his favor, I'll just have to appeal it, because there's nowhere have they been honorable in trying to get this squared away. And nowhere. They have a lack of transparency, a lack of due process, because they either haven't given me the stuff on time or not at all for me to present an effective defense.
Ms.
And if
Grady,
the court
Ms. Grady,
understand.
I've adjourned this case, I don't know how many times, give you an opportunity so that you can be prepared. So please don't interrupt me. Please do not interrupt me. Please.
She's treading on dangerous ground now.
Today we're back here, and I'm not happy with either side. Because one, Ms. Grady, if he didn't send you the information, you could have done what you said you could do, which was figure out how to proceed with the arbitration. And Mr. Best, on this particular case, at each and every turn, there's something that comes up that doesn't go right. which complicates this matter even further. So if she's calling you guys, and now with that particular call, it gets rerouted, and like she said, she doesn't get the call back until yesterday. And as far as an appeal, appeals don't scare me, Miss Gradale. I don't mind that people appeal. That's for a higher court to decide if I've done something wrong. But I try to do my best to do the right thing by everybody that comes before me. And I've given you many opportunities. So, Mr. Best, I don't recall the specifics of that part as to whether there's a package.
I have no package, Your Honor. I have no packet. I have, and what I agreed was I would provide the order granting. Or that's what I believe I was agreeing to provide, was the order granting defendant's motion. It's normally the party who brought the motion's obligation to do the order. My remembrance was she did not know how to do the order, and I agreed to do the order because I have a standard one that we do on these cases. I would never agree to provide legal advice to a defendant on how to file an arbitration.
And that was my thought when this case started. Question for you. Do you think she's straight pro se, or do you think she's sovereign?
I do recognize that my office did drop the ball with respect to the order and getting it to defendant, but I insist that the information I took down is what defendant provided. Granted, we did not properly follow up, and we did not properly respond to her voicemails, but it's strictly the order.
And in reality, where we are right now is this court doesn't have an order in it referring it for arbitration or a stay or any of that, because the order was never submitted to the court either.
So what I would propose is that we provide, I believe it was 45 days originally. I don't want to keep kicking this out, but we go out 45 days, which would roughly be August 18th. And that she file it by then. I am not providing her any instructions on how to do so. I will submit the order under 7 days.
So we are all clear, Ms. Gradiel. He's submitting the order that says that I granted a stay and that you are to file your arbitration within that time period. It will not say anything else or provide any packet for arbitration. It will be your responsibility to figure out how to file your arbitration. Okay?
I hear you, Judge, but I would ask for a dismissal.
That's not how this process works, Ms. Gradiel, and you can file whatever motions you want to file around that.
I feel biased upon.
Okay, then you can feel however you want to feel about that, and you can file whatever you need to file.
Your Honor, if I can, I'm actually out of town the 18th and 19th of August. I would like to be the attorney who handles this. Could we schedule that either? Yeah, I got a dentist appointment on that Thursday. Does the court hold these strictly on Thursdays?
Strictly on Thursdays, and the 18th wasn't an available date anyway.
Right. The 21st would be the available date. I do have a 1 p.m. dentist appointment, but if we could go, I have a very good dentist. If we can do it at 3 o'clock again, that would work.
We're not here on the 21st. He's not asking for that. He's asking for the next date, the 28th.
Okay, I'm sorry. I'm just wasn't sure if you had originally given that.
No, I did not.
Number of days.
So, counsel, you're going to submit the order granting the stay and providing her with 45 days to file her arbitration. And
Correct.
that will be submitted under the 7-day rule. Ma'am, the 7-day rule provides that once the order is submitted, you have 7 days to provide any objections you may have to that order. Court date will be scheduled for August 28th, 2025 at what time, please? 3:00 p.m. This is the last date for that arbitration to be filed. If it is not filed, once again, I will tell you, your MSD will be heard that day. His MSD will be heard that day if it is not filed.
And just for clarification of the order, is it 45 days from today's date, 45 days from the entry of the order, or by August 28th?
Let's just make it by August 28th. When we come back here, that arbitration needs to be filed.
Very good.
Thank you.
Thank you. Have a good day, everyone, and a happy 4th of July.
Well, I'm sure that's not the answer that she wanted. And I think my opinion that she was banking on all of this stuff was kind of sabotaging a little bit. But anyway, we'll follow it because I'm interested to see if she's going to file that arbitration, which the arbitration is when they can take it out of court and have their own little private hearing so she can settle the debt. In my opinion, once again, I don't think she wants to settle the debt. She's asking for the dismissal. So it's going to be interesting to see what happens. Okay, now we're at the next hearing, and let's see what's going to happen in here. Let's go.
The court will call the case of Portfolio Recovery Associates LLC versus Shatina Grady L, case number 24C2622. It appears that we have no one here from plaintiff's counsel. I've been trying to give them at least my standard 15 minutes to show up. This is scheduled at 3:00. It is now 3:14. And nobody from plaintiff's counsel is present. Ms. Grady L, can you state your name for the record, please?
Shatina Grady L.
Thank you. All right, this case was set on the docket today for a status conference update. It looks like, Ms. Grady L, you were to file your demand for arbitration. You did do that, is that correct?
Yes,
All right. So do you have an arbitration hearing date yet, ma'am?
not yet. I had to do an amended also before they can finish the process because initially I asked to have fees waived in the beginning, and then I was able to get those fees handy, the payment for that. So then I submitted an amended and also called them, and I talked to the gentleman and told him I can pay now. And if they send me the link, I can go ahead and pay. He said once the caseworker, I guess they're backlogged. I don't know. He said like anywhere from 3 to 6 weeks out.
Okay. So plaintiff counsel failed to appear here, and it looks like you filed your arbitration. So first of all, what is your request today, Ms. Grady L?
To have the case dismissed.
Case dismissed for failure to appear and for filing with arbitration.
Thank you.
You have to submit an order to that effect, though. Okay.
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 Okay. Well, do I have a couple days to do it, or do I have to do it right away?
It may behoove you to submit it today because today I get to sign it.
Okay.
Just because otherwise it'll be a 7-day wait. Okay.
Okay. Okay. Do I have to type it out, or can I do it in writing, like print? It should probably be typed. Okay. I'll type it and I'll get it in there.
All right. Thank you.
You're
Bye.
Well, she got exactly what she wanted, the dismissal. And I bet you the attorney didn't come back because she jumped on him the last time. And if I was him, I would have made sure I showed up. But case dismissed is all over. So now we're going to another follow-up. And I'm just going to go ahead and put this on. For those of you who know who this person is, you'll automatically know what this follow-up is about. Let's go.
All right. Lastly, you have Destiny
Graves.
Destiny Graves.
Yes, Your Honor.
Have you spoken with her?
Hello.
I have. We're asking can we adjourn this pretrial? I think we can come to some sort of settlement. My client's going to need time to come into compliance.
I don't know if your client.
I'm sorry, I have, hello?
Hi.
Yes. We need to see you
Hi.
now.
Okay.
I don't know if your client has espoused the, what I understand as a sovereign citizen type of, so I don't know if your client is willing to accept an offer. If
Yes,
it
I
is,
have not had a chance to speak.
all right, let's call it City of Detroit versus
No,
Destiny
excuse me,
Gray.
Judge, I'm sorry, Your Honor.
No, excuse me. Just wait a minute. I'll give you your opportunity to speak, okay? City of Detroit
Okay.
versus Destiny Graves, case number SP 1069059, counts 1 and counts 2, SP 172478881, SP 1724805, counts 1, 2, and 3, SP 1724836. Appearance for the record, please.
Good morning, Harry Bachman for the defendant. Would you, ma'am, state your full name for the record?
Are you guys talking to me?
Yes.
Okay.
Yes.
I'm Destiny Graves. That's DESTINEY dash capital RAIVYN. I'm sorry, capital R, lowercase AIVYN, colon capital G, lowercase RAVES. And I'm appearing especially, not generally. I did want to say that I have not had the chance to speak with the counsel privately, and I would like to have that opportunity.
The fact that she's spelling her name that way and saying she didn't talk to the attorney when he just said he spoke to her is a big red flag.
All right, go to the breakout room. That's contrary to what counsel said, but let's just go into the breakout. Let's go into the breakout room and speak with the young lady, Mr. Bachman. Go to breakout room 8, please. Let's pass the matter. Let's go back on the record with Miss Destiny Graves. Mr. Bachman, what does your client want to do?
Judge, my client is continuing a not guilty plea. We already have a final pretrial set for September 15th at 9 a.m. on Zoom and a jury trial set for September 16th. We're going to continue with those matters. My client and I will continue to interact, and I may be presenting a motion for final pretrial, but that would be presented according to the rule by September 8th.
Very well. If it's nothing further, Ms. Graves, have a very good day and best of luck to you, okay? Did she ever come out of the breakout room?
Thank you, Your Honor.
Ms. Graves, are you there?
I'm sorry, I was on mute. I'm here.
All right,
I couldn't see myself, so it's kind of.
If there's nothing further, ma'am, have a very good day. Best of luck to you, okay?
Okay, thank you.
Thank you.
All right, so as you see, she's still playing the sovereign game, reading the sovereign script. I honestly think the attorney's going to be a placeholder. The fact that she said she didn't talk to him when he said they already talked, it's not going to work out. So we'll see how it goes, but I'm sure she's probably not going to deal with him. But put in the comments what you think is going to happen between her and the attorney. Now we're going to go to Colorado, where we have a pro se defendant who had been banned from one of the municipal buildings, and I believe he was trying to have some type of movement for peace. But the way he's talking about the peace, you may want to get some yourself. May want to have you go to the kitchen and get a snack. So for those of you who like popcorn, I suggest you go get it now. Let's go.
And we have the case for James Duncan. Mr. Duncan, is that you, sir?
Yes.
Good afternoon.
Apologize, Your Honor. I was going to be on Zoom, but figured since Mr. Duncan is here, I'll just step in here. Felt weird sitting in my office.
All right, thank you for that, Mr. Reynolds. So we have Mr. Reynolds for the city. We have Mr. Duncan here for himself. And then I do see that we have a few folks who are observing via Zoom, and we have a witness, Mr. Meschuk, who's appearing by Zoom video. I want to just outline this process for everybody so that we're all on the same page as to how we got here. And it started with a suspension notice that was issued by the city, and it was dated on August 15th of 2025 and was served on Mr. Duncan. That suspension notice indicated, and this is the allegation that for the court's consideration, that that Mr. Duncan violated section 5518 of the Boulder Revised Code, and that he was then accordingly suspended from the Penfield Tate building. And that suspension began effective August 7th and would expire on September 6th of 2026. Mr. Duncan filed an appeal to that suspension notice, which he's permitted to do. The court has been designated by the city manager as the hearing officer in these types of situations. So the case came to the municipal court. We've scheduled it for hearing. It comes under the rules of procedure under section 131 of the Boulder Revised Code. And I'll just highlight those for all of the parties. Slightly different than a criminal case. It's not a criminal case. This is a case where you're here on the appeal of a suspension order. So it's a civil matter for the court to consider, Mr. Duncan. And that means that the burden of proof still rests with the city attorney's office. They have to prove by a preponderance of the evidence that in fact you did violate section 5518 of the Boulder Revised Code. And then the court has to determine whether the suspension that was issued, if in fact there is a finding that you violated section 5518, whether the suspension that was issued is the appropriate suspension that should have been issued in the case. So those are the two issues that are there for me to decide as the hearing officer in this particular case. Because it comes under rule 131 of the Boulder Revised Code, the rules of evidence apply, but they're not rigorously applied. They give the court some authority to allow, for example, documents that might otherwise be considered hearsay might be admissible if I think they're reliable. Test something that someone else may have told you, which might be hearsay, might be something that I admit, depending on whether I think it's reliable. It's difficult for me to find that it's to be comfortable allowing what someone else said because they're not here for me to judge their credibility as a witness. So I typically don't allow what would be typically considered hearsay to be admissible in these proceedings. It will have to come from live testimony of witnesses. But documents that people might have submitted or might want the court to consider, those are things that I might consider to be more reliable because they are documents. But it'll depend on the type of document that's offered. And of course, if there's a photograph that someone wants me to consider or something to that effect, I generally admit those. As we go through the process, you may hear the prosecution offer exhibits, and I say prosecution, sometimes I intermix those terms. In this case, it's the city attorney, Mr. Reynolds, representing the city attorney's office. But I may allow him to identify exhibits, and then you'll have the opportunity, if you want to object to the admission of those exhibits, then you can do that. And then I will make the determination as to whether those are legally admissible. The same process would occur for you if there's exhibits that you want me to consider, Mr. Duncan. You can offer them for admission. Mr. Reynolds has the opportunity to object to their admissibility, and then I make a determination as to whether they're admissible. The way the process will work is the prosecution. The city will go first. Mr. Reynolds will call witnesses to testify. You'll have a chance when he's done asking the witness questions, you'll have a chance for cross-examination of those witnesses, meaning you can ask questions of those witnesses. And then when the city is done presenting its case, Mr. Reynolds is going to rest. And then you'll have the opportunity to present evidence. You can testify if you choose to do so. You can call witnesses to testify if you choose to do so. Just keep in mind that anybody that testifies will be subject to cross-examination from Mr. Reynolds, meaning that he can ask those witnesses questions as well. Occasionally, I'll ask a question. If I need some clarification, I might ask a witness a question. It doesn't happen very often, but sometimes I will have a clarifying question that I have to ask.
Judge?
Yes.
If you don't mind, I can't see your mouth. Would it be okay over your computer? Would it
Right.
be okay if I stood up?
Yes. If I hate to make you stand for the whole hearing, though.
I don't mind.
Is it easier for you to see if you're comfortable standing?
I'll be up and down watching that. Yes.
You might be able to see it better if we switch tables.
No, it's the computer.
Okay. I'm trying to I can see it pretty well.
Okay. Okay.
Yeah. Okay. Well, and I can try to move this slightly. Let's do that.
Okay.
That might. I hate to make you stand because it could be a long one. Is that better?
That'd be great.
Yeah, that's fine. Yeah. I wish I were taller, but I'm not. I haven't been gifted that. So.
That's the computers.
Well, if I were a bit taller, maybe you'd be able to see. But it does. At this point, I think we've alleviated the problem. Okay. Good. All right. So I was pointing out that if you have questions during the hearing or during any part of this process, feel free to ask those questions. If they're procedural in nature, I generally can answer them. There may be legal questions that I can't give legal advice on, but most of the time I'm able to answer questions if you have them. At the end of this hearing, I anticipate that I will be able to at least consider offering a conclusion as to whether or not whether I found that there was in fact a violation and whether the suspension was proper. But I may have to take it under advisement and think about it for a few days. Sometimes I have to do that. So I'll let you know at the end of the hearing whether I can do an oral finding or whether I need to take some time to consider the evidence and then do a written finding.
Yeah, it sounds like there's quite an involved process here, and I just wanted maybe to expedite. I'm not as interested in contesting or appealing as it is trying to present an understanding, a perspective, right? So for what it's worth. And so the only option I have is to appeal, and that's why I chose that. So.
Could I suggest that maybe I could talk to Mr. Duncan in the hallway real quick, and then we can come back in about a couple minutes?
Yeah. Mr. Reynolds could probably give you, some feedback on what might occur and you all can have a conversation. If you decide, hey, I don't want to contest the suspension, but I do want to give a statement on the record, that's something that I could easily accommodate by having you do that. But why don't you have the conversation with Mr. Reynolds? You do have the right to the hearing, so I don't want to take you from having that right. But if you want to have that conversation, go ahead. And we'll just go off camera and off the record for a moment or two.
It's a shame with this hearing, we don't really know what went down. Let's keep going.
And we are back on the record for Mr. Duncan's case. Mr. Duncan and Mr. Reynolds had a brief conversation to discuss his options. Mr. Duncan, we talked about it before you left, is whether you wanted to have the full hearing and require that the prosecution prove by a preponderance of the evidence that the suspension was proper in this case. But you've indicated that you may want to simply just give a short kind of, I don't know if it's a speech, but a statement about what took place. Is there a resolution that's been reached, Mr. Reynolds?
I'm not sure.
Okay. So option A is we just have the hearing. Mr. Reynolds will put on Mr. Meschuk and perhaps other witnesses who will testify, and then you'll have a chance to ask them questions. And then you could put on witnesses, which I've described earlier, and there would be a full process. Or the other option is if you choose to waive your right to have a full hearing, then in a sense, your appeal would become moot because you've waived your right to have the hearing and the suspension would continue on until September 6th. It's not a criminal case, so it doesn't end up as a criminal record of any sort, but that's kind of what your two options are. If you decided you wanted to give a brief statement and waive your right to the hearing, that's the other option for you. What would you like to do?
I will choose the latter. Make a statement and drop the appeal.
Okay, so you want to waive your right to have a full hearing today and simply give a statement.
Right.
All right, and that's fine with me. You understand that means that you can't physically go to Penfield Tate between now and September 6th. After that, you're allowed to go back to Penfield Tate. I think there's a city council meeting that is September 4th, so that would be the one that you would have to watch. You couldn't actually physically go and watch that city council meeting. You understand that? Okay, so I'm going to find that defendant has agreed to waive his right to have a hearing and is withdrawing his appeal. But before we do that, if you'd like to make a statement, feel free to do so. Mr. Meschuk's here, Mr. Reynolds for the city attorney's office, and Mr. Altenberg, who's also from the city attorney's office, can hear what you have to say, and I can as well. I don't have any impact on city council's actions or city attorney's office actions, but if you'd like to give a brief statement, go ahead.
Thank you very much. Can you hear me? Is the microphone?
You can pull it closer to you. It doesn't amplify your voice, but it does record it. Okay. So go ahead.
Okay. I'm glad to know that Mr. Meschuk is here because I would like to address you as well, Chris, Mr. Meschuk. I've got several things to say. One is that how do I start? I do a lot of volunteer work, and I'm very interested in peaceful proceedings and orderly process and solving problems. I want to be an asset to the community. I don't know if you remember that the night of the incident, that I was downstairs pretty much the whole time, and with a table of some literature, and I'm trying to encourage people to have discussions. And one way I do that is through making popcorn. so that I was calling popcorn for peace. Because I want people to dialogue, because there is a tremendous conflict at foot, right? And Mr. Meschuk, I don't know if you remember, but I mentioned to it that you as a city need to address that conflict, right? I'm going to say that I don't agree with this particular method of trying to solve it by stomping out dissenting voices. I don't think that that's helpful. That if all you have is a hammer, all your problems look like nails. I suggest you get more tools, right? And I'm trying to create tools. A year or so ago, at the very beginning of this conflict, I was making popcorn as well. And up in the chambers, there was a shouting match started up, right? So the way I addressed that is I said, you two need to go downstairs and have some popcorn.
Now, if you're already upset and you get some popcorn stuck in your teeth, that's going to make it even worse. Who gets popcorn when they get upset?
Because that's the way resolutions are created and peace is made. So that's one. Second thing is that I have to commend Denver Water, that they have an approach that was very effective. I got a knock on the door one morning and I had no idea why. Right? And the Denver Water guys tell me about the virtues of the water and how precious it is. I come from Wyoming, and believe you me, I know water rights and how contentious it can be. And he was so obsequiously nice of trying to motivate and educate me. And it turns out that he saw that I had left the sprinkler on for an extended period of time. Right? And that's all he wanted to do, is to say, like, we don't waste water down here in Denver. And that story I remember because of his approach, being positive, being proactive, being personable, right? That is the kind of approach that I would suggest you do. I know you're the deputy manager and city council has the power, but John F. Kennedy made the statement: those that make peaceful revolutions impossible make violent revolutions inevitable. So by the city council and others using these forceful hammer tactics, you're only creating more problems down the road. And I'm trying to help you with solving those, because this is my hometown. This is my town, and I want a beautiful place here. I do have to say also that it's been in the city council building downstairs in the lobby. It's been loud before. Cheers have erupted, and no action has been taken then, right? And so that's happened before. And I guess the only thing I would say is there was no warning, right? So I mean, if you had said, like, this is the last warning that you will be suspended from here, then I think I would have chosen differently. But there was no warning. So I have to say that. Yes, folks, I'm with you, Chris, and Mr. Meschuk, and I wanted to say one thing. Another piece of my background is that I was a cheerleader up in Wyoming, and we knew crowd control because what was going to happen. And so that when the crowd started getting a little bit negative, we refocused that energy into positive cheers. So that's what I was doing. When Aaron and others were starting a shouting match, what I did is to start a positive cheer, right? I took that energy into a positive direction. So if you want to hold me accountable against that, that's your right. That's a hammer. And again, I encourage you to find other tools besides the hammers. And the last thing I wanted to say is that this issue that's going on, as you can tell, it's not international. It's local. It's everywhere, right? The contentious, the conflict that's happening here is between Zionism and Islamophobia, right? And it's happening. And yes, what's precipitating that is the genocide, the Holocaust that's happening, right? And John Lewis, the city put on a program a couple of months ago for Martin Luther King Day, where they had a speaker who knew John Lewis very well, Martin Luther King, and he was talking about good trouble, right? And so that's what we're trying to do is produce good trouble. And if the city can't respect that, even though they put on a program touting that good trouble, I mean, that's just so hypocritical, and it really does not bode well for the city. I want to mention that. Yeah, that's all. Thank you very much.
Thank you for that, Mr. Duncan. Okay, so that will wrap things up. I'm going to do a short order. It'll be emailed to you so that you have it. That just basically shows that at this juncture, the appeal has been withdrawn. There won't be much more to it than that. But I appreciate everybody appearing today, and you are all free to go.
Thank you.
Thank you.
Thanks, Your Honor.
And we can go off the record. Thank you.
All right, in regards to this last hearing, I think I know why he might have been suspended. He might have been kind of calm in court, but he might have been a little bit too aggressive on how he was doing things. He wanted it done a certain way, and I think he was probably adamant about it. I guess they couldn't control what he was doing, so they just suspended him. I hope you enjoyed all the videos. I thought that was something different on the last one, and when he said that popcorn for peace, I was like, all right, I had to go in on that. So look, if you ever get upset about anything, go get you some popcorn, with or without butter. Don't ever get the kernels in your teeth. That's the word for the day. See you on the next one.